Nice to see everybody here. My name is Christopher Young. I'm an attorney here in Camarillo and with the Alvarez firm. I always introduce my firm because even though these are the things that I focus on, elder law, special needs planning, probate and trust administration, and litigation related to all of those things, the firm also has a business and real estate practice, and we have offices in Camarillo, Westlake Village, Calabasas, and now, very recently, San Juan Capistrano. So if you know anybody in those areas who needs assistance, feel free to just give me a call, and I can put you in touch with a good attorney. If it's not me, that's fine. Sometimes I get somebody at the firm. Sometimes I get the question at the end, now who are you again? So I always mention a few things about myself. I am a certified specialist by the State Bar of California. That is an extra designation that requires additional testing and education. And it's something that it's a fair thing to ask the attorney you're dealing with, are you a certified specialist? It helps distinguish attorneys who do a bunch of different things, a little bit of each, from those who just really focus on this area of law. Also, for reasons I have yet to comprehend, I was voted by my peers as Southern California super lawyer. It's the top 5% of attorneys practicing in this area. So for what that's worth, we mentioned that here as well. Most important, a little bit, I play this, and especially I've been playing since age 4, and if you like folk music, that's an area that I really focus on. If anybody ever watched that Civil War series that Ken Burns did and liked the soundtrack, well, then we're two of a kind, because I do too, and I play all that music, the Jay Unger, Molly Mason, Ashokan Farewell, that kind of stuff. So if you like that, so do I. I'm from, who knows what city this is? Portland, Oregon. That's Portland, Oregon. That's Mount Hood in the background. City of Roses and Antifa. And that's where I moved here in 2012 because of this lovely lady. That's my wife, Sarah. There's a quiz at the end on her. And these are our 5 littles. And they are age range from 7 to 15. So that's a fairly recent photo. All right, enough about me. But do remember my wife's name, because that'll come up at the end. So we're here to talk about someone died, what now? And since every case is slightly different, the best way to approach it is more generally about what is involved in estate administration. So that's the approach I'm going to take. But again, your specific questions are fine. We can handle those here, or we can talk offline afterwards if you have questions that we don't touch on specifically here. So when it comes to estate administration, there are 2 main things we look at. First of all, we look at whether someone is testate or intestate. Okay, so has anybody ever heard of a will called a last will and testament? If you have, then you know that testate means has a will. Okay, and intestate is the opposite, passed away without a will or without any sort of estate plan. And then, specifically within those, we look at whether somebody had a will or a trust. Okay, so those are 2 very common types of estate planning tools, but not everybody is limited to just that. If it's a married couple, sometimes we have the ability to transfer property at death between married couples through another process called a spousal property transfer. And just to make it more complicated, because there's all sorts of options, and there's no one size fits all with any one person. We have other types of non-probate transfers, so we'll touch on those. These are ways to get assets from one person to another without a will, without a trust, and even if you're not married. So we'll touch on those as well. So we have a lot to cover in the time we have. But I thought it's important to talk about people, if you in your own life do not have an estate plan, you are in good company. And here are a few people that died without estate plans. This one we all know, Dr. Martin Luther King Jr. He passed away without an estate plan, and his family fought for years over 2 items of personal property that were specific to him. Does anybody have any idea what those might have been? Bible. Anything else?
The speech.
That's a good. It's a good guess. The speech, no, but something that he was awarded in his life, his Nobel Peace Prize. Okay, so those 2 things, but that's an actual picture of his Bible, and so the family was very interested in who got that. And because he didn't have an estate plan, there was some argument over who would receive it. This fellow we all know died a few years ago in Minnesota. His estate has recently been settled. It was estimated at about $163 million and change. A whole lot of new family members came out of the woodwork when he passed away. And there was genetic tests and all sorts of things. So again, a long, drawn out, where the lawyers in Dickinsonian fashion probably got a bunch of the money. And so, we try to avoid that by having estate plans. This fellow, probably the most famous lawyer in the country, our 16th president, passed away without a will. You might say, well, it's not entirely fair that you're on his case because he did pass away younger than he expected. But if anybody's read a book called The Lincoln Conspiracy, you know that it's actually that was the second attempt on his life. In the train ride from Springfield down to D.C. when he was about to take office, there was quite a process of trying to assassinate him on that trip, on that train ride. It's a fascinating story if you're looking for some true caper there. So, and he was dressed in disguise as an elderly woman, a very tall elderly woman. Very interesting story. But so he did have a little bit of a warning that he had some enemies, but he still didn't have a will. So it took a while to administer his estate, which was worth about $110,000 in today's dollars. I'm sorry, that was in those dollars, several million dollars in today's dollars, $110,000 in 1860s dollars. And then this young man, and this is a really sad situation because it really gets to the heart of why we're talking today. James Dean, he was raised by his mother. His father was not part of his life. And then when his mother passed away, his aunt and uncle continued to help him and support him. But he died suddenly and tragically. And who do you think got his estate? His estranged father. So those are some of the unintended consequences of not having that estate plan in place. We'll talk about one other person in the future here who did have a will and it still had unintended consequences. So we want to pay attention to exactly what's in the will as well. Since I have little kids, and you know that now, there's a lot of quizzes going on at our house. So I thought a true or false quiz might be good for us. So true or false, who thinks that a properly drafted will avoids the need for probate? Just a show of hands. Does anybody think it's true? We have a really smart crew here today. I don't know why I'm even here, Blair. I kid, but you're absolutely right if you thought that was false. But it won't surprise you to know that that's a very common misconception. Many people tell me, well, I won't have probate, I have a will. There's really only two ways to avoid probate if you have a will, and that is to die broke, which many of us will successfully do, or to die at least with less than $184,500. And we'll talk about that number and what that means in a minute here. But essentially, a will is a letter to a judge. It says, "Dear judge, please do this stuff, or do this with my money, and here's who I want to do it." And that's all it is. And the judge is in charge of appointing an executor or an administrator if you didn't name the person who's appointed. Those are some terminology. So if you name a person in your will, they are the executor. But if the person who is appointed was not named in your will because they passed away or they weren't available or the judge went with somebody else, then that person, instead of being executor, is the administrator of your estate. I went through many years of life thinking it was executor. So it's okay if you thought that as well, but you don't actually get to name your executor, but you do get to name your executor in your will. So let's talk about what probate entails. And mostly the point of this is to find out why we should do what we can to avoid it. It is a court process to distribute an estate. And like I said, there's a $184,500 limit. That number changes every 3 years in California, but that's the current number to avoid what we call a full probate. A full probate is going to court and having the judge set up the case and having to make all the reports and accountings and all of that's involved. That is based on the gross value of an estate, all right? So think about the real estate that many of us in this home, or in this room hold, and you start to realize that anybody with real estate in Southern California is going to be subject to a full probate. We're just not going to be under that number because it's the gross value. They don't care how much you owe on it. It's just what is the value. And again, like we said, the existence of the will does not avoid the probate, simply removes the guesswork. So there are some other limits within the 184,500, and we'll talk about those in a second. But when we went to this slide, we were way back there. We talked about some terms there that I want to point out. We talked about heirs, and we talked about beneficiaries, and then the probate versus trust, the public and private agreement. But heirs and beneficiaries are very important terms that we need to keep in mind as we discuss intestate and testate transfers at death. So coming back to this, let's talk about what happens if you have no will, no estate plan at all. Then you have what's called intestate succession, and we care about who your heirs are. Your heirs are the people who will receive your estate at your death if you have nothing in place. By definition, we start by looking for a surviving spouse, but many of us will not have a surviving spouse. Even if we were married, we may survive our spouse. All right, so then the statute, this is the default in the law, because technically, even if we don't have an estate plan, we have an estate plan. It's just in the probate code, and it was written for us, and we didn't have any say in it. So the default provisions say, okay, we look next to issue. And issue, as you see there at the bottom, is anybody below the person who passed away in the family tree, in that bloodline. Okay, so we're looking for children, grandchildren, great-grandchildren, and so forth. Those are your issue. What if you pass away without a surviving spouse or issue? Well, this is where it gets interesting. And a lot of people come to me and say they want an estate plan because they don't want the state of California to get their money. That's very understandable and reasonable, but I just want to draw attention to the fact that the state of California is the last resort. Okay, there's a lot more people they have to get through before we do what's called escheating to the state of California. But I want to note a few of those people. First, we look at your parents, any siblings you have, any nieces or nephews. Then we look at your grandparents, your aunts and uncles and your cousins. Then we go to the stepchildren. And then we go to your next of kin, whatever that means. I think that just means anybody that's in the blood that's next in line after all the people we've gotten through that we couldn't find. And here's where it gets really fun. You may actually want to put the state of California ahead of the next category, but that is your in-laws. All right? So these are the parents of a predeceased spouse. Oh, and their children, the brother-in-law, the sister-in-law. They all stand to take before the state of California. And that can be a deceased spouse. That would be a deceased spouse. If your spouse is living, they got it first. So we're talking about your spouse has passed away, and now we're talking about the in-laws, the parents and siblings of your deceased spouse. And then, and only then, does the state of California get it. All right? Now this has to do with property that was subject to intestate succession. So let's talk a little more about those rules. Has anybody here heard of community property? You should, because you live in one of the few community property states in the country. They're mostly clustered on the West Coast. We have community property and separate property. Community property is property that was acquired during marriage, or it was separate property that was changed into community property by an explicit act on the part of the person who had it. So we should ask what's separate property. Separate property is property you brought into a marriage. You acquired it before and brought into your marriage. If you owned a house already, you brought that in, that's separate property. Or it's property you inherited or received by gift during a marriage. So a very common question I get is, what happens to property my child inherits from me while they're married? Does it go to my daughter-in-law or my son-in-law? No, not unless there's an affirmative step taken by the inheriting child to do that. Now, it could be as simple as commingling that, putting all the money in a joint account. That may do the trick, okay? But so you need to tell your children to be very careful and keep their inheritance from you separate if they intend to do that. But as a practical matter, property received by inheritance or gift during marriage remains separate property. Okay, so now we care about that property. When does it matter? That matters in a dissolution, a divorce, and that matters at death when we're talking about intestacy, because the surviving spouse receives all community property they get everything if there is a surviving spouse, but only some are all separate property. So if there are no children, or issue, I guess the slide should actually say issue because grandchildren would come into place here. If there were no children, or if there are no living children and no issue, then they get all of the separate property as well. But if there was one child, one extra branch of that family tree, the surviving spouse splits the separate property with that child or that issue, okay? What do I mean by issue in this case? If there was one child who had two children of their own, so there's two grandchildren, but that child then died before his or her parent, then the grandchildren would get the half that was intended for the spouse, for the child who lived, okay, or for who passed away. Sorry, the grandchildren would get the portion intended for the child who passed away. If there were more than one child, then it's divided. Hang on a second. 1/3 to the surviving spouse and 2/3 to be divided among as many children as there are, or issue by representation, the grandchildren if the parent has passed away. If there's no child, but there was a parent or sibling of the deceased spouse, the parent or sibling takes half of the separate property. This is the one that gets everybody, and I've actually seen it in action in court. The deceased spouse passed away, there were no children, but they had a sibling who was living. That sibling gets half of the separate property. And I've seen this with some really tragic results, of great surprise and consternation to the surviving spouse who went to court and tried to claim title to these assets and found out, no, their spouse's brother intends to take his half, or whatever the case may be. So be aware of some unintended consequences that come up when it comes to division of property among spouses at death. Okay? That was very complicated and we went through it fast, but again, I can answer any questions about it later. So if you do not leave it to chance, you have a last will or testament, then we have testate succession. And then instead of heirs, notice we've been talking about relatives only. But instead of heirs, we now look at beneficiaries. A beneficiary is a person you've named in your estate plan to receive. Oftentimes, an heir and a beneficiary are the same person. I have 5 children. They will be my beneficiaries as long as they all send me Father's Day cards. So for those reasons, heirs and beneficiaries are often the same. But let's throw a wrinkle in. Say that you have a charity, a college or a nonprofit or church that you want to leave some money to. They are not an heir, but they are a beneficiary of yours. So we care about who the beneficiaries are. They may or may not be heirs. Conversely, not all your heirs may be beneficiaries if they stop those Father's Day cards, for instance. So in that case, we need to look at what happens when we disinherit or we omit children or spouses. It can happen. So what happens if we don't name a spouse in our estate plan? Whether you realize it or not, your spouse is still entitled to claim on your estate. An omitted spouse receives what's called their intestate share. What does that mean? They would still get the community property. They would still divide the separate property. So if you intend for your spouse to get something less than that in your estate plan, you need to say that in your estate plan and be very clear. I am omitting my spouse. I've made other provisions. We have another agreement between us, whatever the case may be. Okay, so keep that in mind because it can lead to some unintended consequences. What happens if the omitted person is a child? Well, if it's a child born after the estate plan was done, then we assume you meant to leave to them, but you never had the chance to update your estate plan, so they get their intestate share out of your estate. If it was a child that was born before the estate plan was done, but just not mentioned, then that child bears the burden of proving that the parent believed the child was dead at the time they made the estate plan. That's going to be a rare situation. Otherwise, likely nothing. But there's some case law on this. It's rather complex, and it would take a lot of money to get to the bottom of this, which is why a very simple solution is to address all possible people, spouses, children, anybody who could take. Put it in your estate plan. A very simple thing you can say, which might avoid ruffled feathers, is I am intentionally leaving no provision for Susie, but not for lack of love or affection. Susie can read between those lines, okay? It's because I haven't heard from her in 50 years, right? There's other reasons. I still love her, but I'm not leaving her any of my estate. Those are reasons that you can put in your estate plan, and what it says to a judge is, oh, they didn't forget, they knew what they were doing. So it's important, if the intent is to disinherit, it's best to specifically do so, okay? All right, so let's talk about what probate, remember this is going to court, whether or not you have a will, what it entails. A lot of people know that they should avoid probate, but they don't understand why. Something I forgot to mention at the beginning is I'm licensed in Oregon as well, so that Rose City there. So if you have any friends or a property in Oregon or anything like that, I can help on for both states. I also used to be licensed in Michigan, but my Southern California wife said I would have to be single again if I ever moved back to Michigan, so I resigned Michigan, stopped paying those bar dues. But I mention that because in the 3 states where I've practiced law, California is where the probate gets the bad reputation. It is, as it says there, costly, lengthy, and public. And down in here in this part of the state, there's a lot of people who value their privacy and they prefer to do things without having it all hashed out in court. That said, if the soaps are just not doing it for you anymore, any Wednesday or Thursday morning at the juvenile courthouse on Vineyard, right there's a probate courtroom in that courthouse. It's the courtroom 6 there. You can sit in there all morning long and find out who loved mom more and why estates should be divided differently than what the documents say. There's all sorts of drama that goes on, and it's free. So just know that not everybody values their privacy as much as some of us, and so there are some very public estate distributions going on. But I like to focus on the costs and the length. And so I give some examples here of what a probate costs. And these are just examples, but remember, this is gross value. So $400,000, and again, if we own property here, very few of us have $400,000 estates. Probably not too many of us have $800,000 estates over the last few years, the way property values have been. Most of us probably need to look at that $1 million figure or go higher. The fact is, $1 million estate is $23,000 probate attorney fee. That's set by statute. $23,000 to your administrator or executor. And then the court, as you see there, they get $435 for every petition filed. By the way, it's a petition to open, a petition to close, and a petition to do anything else that you want to do during the probate. So they're getting money constantly. And then the person who's charged by the court to value your estate, because they don't take our word for it on what the values are, that referee or appraiser gets a piece of the pie as well. So it's very easy to see how $1 million estate, if everybody took their fees, could be $50,000. And that's where a lot of people have this 5% idea. It's not always 5%, but it's a big chunk of the pie, okay? Now, I can say that the executor, if it's a relative, this is taxable income. They may say, you know what, I don't need that extra taxable income. I may be a beneficiary, so I might be getting some of it in an inheritance, which is tax-free, so I'm okay waiving my fee. But let me speak for every attorney in Ventura County who does probate and say that we probably won't be waiving our fees because there's a lot of work involved. So the attorney's going to take their fee. And so just be aware that there's these costs involved, and then you start seeing why having an estate plan can be a better idea. I mentioned that there was somebody else we were going to talk about who had an estate plan, but it didn't work out the way they wanted. Everybody knows who this is. Norma Jean Mortensen, also known as Marilyn Monroe, and she passed away, and she had a will, and she left her estate to her manager because she trusted he was going to dole it out to the people that she would want to receive it. And she also liked his wife at the time. Well, she didn't like who he ended up being married to when he was passed away, and the bulk of her estate went to his second wife and did not go where she intended. So again, there's reason not only to have an estate plan, but also to make sure you update it, keep it current, and just be very explicit about what you want done. You don't have to necessarily trust another person to take it and do the right thing with it. All right, so we're moving along. I have another true or false question. Who thinks that adding the name of a child or other family member to your assets is usually a good idea? Some homespun estate planning. I'm seeing a lot of no's. It's okay, even if you think it's a good idea, you don't have to raise your hand. I think that's false. And so this is our entree to talk about non-probate transfers, because after that last section, you may be saying, well, how do we avoid all of that? And so we're going to talk about that for the rest of the presentation, but the one that comes to most people's mind are non-probate transfers. Why don't we just put Johnny's name on title on the house now? Why not put Susie on my bank account? So let's talk about what some of those mean. So the most common one that comes to mind is joint tenancy. But within joint tenancy, there's two main categories. We have married couple joint tenancy, good, and we have non-spouse joint tenancy, bad, okay? So it's very common and a good thing to put our spouses on joint accounts. That's for, cash flow and for convenience and for all sorts of reasons. It makes sense to have our spouses on an account with us. The exception, if you think back to what we talked about with the gift or inheritance that you receive that you intend to keep separate, then you don't do that. Don't put gifts or inheritances you received from your own family that you want to keep separate. Don't put those in joint tenancy. But with non-spouses, it's generally a bad idea. There's exceptions to every rule, but generally a bad idea. So let's talk a little bit about this. Similar to community property, married couple joint tenancy gives both spouses access to the funds. It's not the same as community property, though, and I'll mention one big way. If you put a spouse on title to your home as joint tenants, when you die, we're getting a little into the weeds of tax law here, but when you die, you get what's called a step-up in basis, in tax basis, to the value of the property at the date of your death. If it's in joint tenancy, your spouse, it's not a complete step up. It's only a step up as to your half interest in that property. If you instead hold the property as community property with rights of survivorship, that still has the effect of the spouse receives it at your death, but there's a complete step up in tax basis. And there's some practical reasons why that might be a good idea. For instance, if your spouse then wants to turn around and sell the property to downsize or something like that. So just keep in mind, and again, this is something we can talk about specifically if you came in and we rolled up our sleeves and looked at your own plan. But the idea there is to not just think that joint tenancy is exactly the same as community property. It's not. Also, married couple joint tenancy doesn't solve the problem for both of you. Yes, it does mean that at the first spouse's death, almost everything will transfer automatically to the spouse who survived. So that's a good thing, and you don't need to come see Chris about this or the judge. But what happens when the second spouse dies? You still need to have an estate plan. So it only works at the first death. The second kind of joint tenancy that I want to touch on is the non-spouse joint tenancy, and I've listed just a few reasons why this should be something you do very rarely and consider all of these things. First of all is loss of control. All right, so now, someone else has access to this account or this property. They may have creditors. They may be in some debt, and so the creditors may come and try to collect against that property. There could be tax disadvantages. I mentioned that step up in basis a minute ago. The fact is that if you give property away during your lifetime, there is no opportunity to have that stepped up basis. So there may be capital gain consequences, for instance, if you give away property, especially highly appreciated property during your life. And then there's possible public benefit disqualification issues. So we just need to look at what we're giving away. So think about Medi-Cal and think about look-back periods and all those things that we're not going to get too far into today, but just think there might be other consequences to making this gift, because that's what it is. If you put a child or another person on title on your property, whether it's real estate or personal property, you're making a gift. You're giving them an interest in your property. So just think through all the consequences of doing that. Yes, I see a question. Okay, so the question was about stepped up tax basis. So what I was referring to is when we die, we have a capital gain basis of what we paid for a property plus any capital improvements, and that is disregarded from that point forward. And now our tax basis for capital gain purposes, whatever it was the value when we died. So if our children or whoever inherits the property sells it the next day, there would be no capital gain. In Camarillo, I know of a number of people, you may be one of them, where you bought the house in the 60s or 70s and it's worth 10 times as much now, easily. And if that's the case, then you have a highly appreciated asset, and tax basis matters. And you want to have that stepped up basis at your death so that nobody pays capital gain at 20% or whatever capital gain rates are at the time at your death for whatever, for the property, and gives away to the government that appreciation that you have. I see one other question back there. We'll touch on that. Go ahead.
It's only for real property, not for stocks.
No, this all applies to, the question was, is it just real property or other types of assets? This applies to any asset that's appreciated, right? So if you bought Microsoft in the 70s, that's a highly appreciated asset. And you should be very careful about making sure you pay attention to capital gain on that as well. Okay, so we've talked about transferring by joint tenancy. What about other types of transfer? This is probably the second most common, and that is beneficiary designation. Think about these types of assets. You surely have at least one of them, if not more. These assets are given to successors or to beneficiaries at your death by contract. This is something that I'm going to stop for a second because I notice people are like taking photos of the slides, and I want to just offer, if you took my business card, I have an email address on there. Please don't hesitate to send me an email, and I will send you these slides so you don't have to worry about writing every last thing down. I'm sorry I didn't mention that earlier. So, but if you have any of these types of assets, they will pass to by contract, a contract that you've established with the life insurance company or the retirement plan holder or whoever it is. When I die, I want it to go to these people or this person. So that is beneficiary designation. And other type, we want to use these with caution. You can set up a bank account. You can set up an investment account to be, by contract, go to somebody at your death. And you may be thinking, wow, this is a cheap way to do an estate plan. But you have to make sure that those people are still there. You have to know that they're going to be living when you die. Otherwise, the contingency planning may leave something to be desired. You have to look at the fine print on those forms and see what happens if the person dies before you. A lot of people don't think about that. It's an assumption, a safe assumption, that our children will be there when we're gone. But it's not a guarantee. If we've learned anything the last 3 years, life comes at us fast. So we got to do the contingency planning, which a proper estate plan can allow you to do. So those are pay on death or transfer on death, POD or TOD. And I do want to mention we have something rather novel in California called a transfer on death deed or a TODD. And those are being piloted. They're here until 2032 for the time being. And it's a way to pass real estate on by deed at your death, okay? And I'll say that it serves a purpose if you are in late stages of a terminal illness and you know that it's going to be any minute now. Sure, do this if that makes sense. But you really, for the same reasons, you've got to make sure that the person is going to be there when you're gone, that you're leaving this property to. And if they're not, it's going to default back to your estate, and you're going to have a probate, and it's going to end up in the in-laws' hands or whatever the case may be. So you just need to. There's no perfect alternative to a properly done estate plan. Is I guess where I'm going with that, because of the contingencies that we have to account for. All right, so other types of transfers without probate. This is the most common type of probate alternative. So you have an account and it's $50,000 and it's just in the name of the person who passed away. And they have nothing else out there that's when you add it together, puts them over, that is a typo. It's not 1,184,000. It's just, that should be just one there, 184,500, okay? If that's the case, when you put your arms around everything else they had and you don't get over that hump, that 184.5, then you can, if there's no real estate, you can do it by affidavit. You can present an affidavit called a small estate affidavit to the bank or to the life insurance company or whomever it is and say, I am the one who's supposed to get this under the will, and I don't intend to go to court because this is a small estate. A lot of banks have their own forms for this. If they don't, or if they tell you to come with your own, I can help you. That's something an attorney can draft, okay? We know what the form should say, But I always tell people, go ask the bank if they have a pre-printed form that they like using. Even if you get their form, chances are you'll have questions about how to fill it out. So it's something that you can ask an attorney for help there. You have to wait 40 days from the date of the death of the person who passed away. I don't know what's magic about 40. It's rather biblical sounding to me, but I don't see any other reason why 40 days is in there, but that's the number. That's the number we look at. And notice that I said no real estate is involved. So a couple of things here. One is a couple of things are not included in that number. The cars are not included. We don't have to worry about the value of a car because that's a moving target. So the law specifically excludes cars from the 184,000. You don't have to worry about that. Similar, anything else titled through the DMV is excluded. Mobile homes, boats, things like that. So this actually can be very helpful to avoiding getting over that number. Again, with questions, give me a call. But all we're really thinking about here are stocks, cash, investments that are not real estate. So let's talk about the real estate. For whatever reason, the limits with real estate are different. If there's anything more in the estate, and remember this number is moving, but it's 61,500 right now, then you do have to go to court. There's a separate process for handling property between the 61.5 and the 184.5. Okay, so there's this extra tier, this extra level of work that needs to be done if we have real estate between those two values right there. Okay, what is involved? It's a court petition to determine title. It's not a probate, but it's still a petition and a hearing and getting an order from the court and getting a certified copy of it and recording it in the chain of title. There's a lot of work involved, but it's not a probate. And the other strange thing is you have to wait 6 months before you can do it. Let me give you an example of when this actually has come into play. Does anybody here live in Leisure Village? Okay, a few hands going up. I know that to be a voting member over there, you need to own property in the village. At least that's what I've been told. So some couples will say, okay, even though this is one spouse's house, they'll give 1% of the house value to another spouse to get them on title, so they're a homeowner and I think this happens in a lot of places. So the idea there, when that spouse passes away, how does that 1% get back? And this is oftentimes the 1% will fall under that 61, or fall into that range. So if it's a $700,000 house, that 1%'s $7,000, right? Are we talking about? So I guess, yeah, but I guess you can even do it for less than that. That's right. The whole point is that we can do it by affidavit. That's the part I neglected to mention. If we're below the 61.5, then we can do it by affidavit. Again, we have to wait 6 months to do this. Okay, so we can go to court and file an affidavit with the court, get a certified copy back, and that will actually affect the transfer. So if we're below 61.5. And so I have done that for some residents of Leisure Village. Okay, similar to these other transfers without probate is the spousal property petition. And I'm seeing some heads nod. I'll bet some of you have had some interaction with this. But this is a way to get property that belongs to one spouse to the surviving spouse at death without going through probate. It's a court process, and it's a way for the court to say, yes, title may have been held in the name of the spouse who passed away, but this was community property. So remember, we're going to shift it all over to the spouse, the surviving spouse, because it was community property. But we still have to have a court process for doing this, but we don't have to go to a full probate. We can do this with a single petition and a hearing. The court will want to know a lot of things about the marriage and who brought property into the marriage and how long the marriage was and who earned what during it. I mean, there's a whole lot of information that you have to provide the court. But ultimately, if you qualify, it's a way to get property from the first spouse to die to the surviving spouse without having to go have a full probate. One of the things I didn't mention when I was talking about the costs and time of probate is the time. I didn't get into that, but oftentimes probates in California take upwards of a year. It's very common. And the proof of that is the law requires that the executor or administrator file a report to the court at the 1 year point and every year thereafter about what's going on with the probate. And that tells you something about how long these take. The other issue with probates is you have to give notice to not only the state franchise tax board, but also the Department of Health Care Services to see if there was a Medi-Cal claim. You have to give notice to any known creditors. Do we owe you anything? Let's pay it off. You have to publish notice in the paper to unknown creditors. There's all sorts of things that have to be done in a probate that you can avoid without a probate, and that may be what was intended by the person who passed away, but you have to go through all those processes if you have a full probate. So there's reasons beside just the cost why we try to avoid it. So I did have a slide to talk a little more about the spousal property transfer. So in the interest of time, we'll go through this rather quickly. But again, if things were held jointly, then we don't need to use this process. It really matters for assets that are held just in one name, one spouse. Oftentimes you'll have real estate that was acquired during the marriage, but just held by one spouse. Why? Maybe they had the better credit, so they went on title to get the mortgage. This happens very often. But then they pass away, and how do we show that really this was community property, that this house belonged to both spouses? We have to go to court and get it done that way. So that's spousal property transfer. And then again, with separate property, if you're inheriting some or all of the separate property, you have to have a court order, and you can do that through the same spousal property transfer. It only works for the first death. Obviously, at the second death, we're not going to be able to have a surviving spouse, to use this. So at this point, you may be thinking, wow, that was a lot more information. How do I avoid this too, even though there's ways short of a full probate that we can avoid by, a joint tenancy or contract or a spousal property petition? How can we avoid that? So in that case, last true or false question for the moment, but who thinks that trusts are a good idea even without substantial wealth? Right? So that's a true question, or true statement. So the reality is trusts can avoid all of the things that we just talked about. Okay, by having, because the whole idea of a trust, well, let's talk about trusts. A trust is a legal arrangement where someone holds title to our property for someone else, for a beneficiary. There's three main players when it comes to a trust. There's a settlor, a trustee, and a beneficiary. If you see the letters OR at the end of the name, that's the same as settlor. There's grantor. You'll see that sometimes. Your trust may say grantor. You'll see creator. I don't like that one. I think that's presumptuous. But creator, same idea. The OR means they made the trust. And then the trustee is the person managing it. They're the manager. And the beneficiary is who gets the property. When you start a trust, most likely you are all three of these. Right? But at some point, because of loss of capacity or death, you'll stop being the trustee. And at some point, usually because of death, you'll stop being the beneficiary. And the beautiful thing about a trust is it says, when I'm gone, this is who gets it. And we avoid court. We avoid all sorts of extra time-consuming, complicating factors by just having this document that says this is what's supposed to happen when I'm gone. So this is the benefit of a trust. But there's other benefits too. So it manages distributions of your assets during your incapacity. So you can have rules set up. Say you have a child or a dependent who needs your assistance while you're alive. You can have rules set up. If I'm incapacitated, please help support Susie. Please continue to give money to her. She needs my assistance. Or pay Johnny's rent. You can put those rules in a trust. They can be very flexible. They, of course, avoid the probate costs and delays that we talked about. It allows you to maintain that privacy and control. Okay, so no Thursday and Wednesday morning soap operas down on Vineyard at the courthouse. And for those who have concerns about estate tax, right now that number is rather high, so I haven't talked about it, but that's $12.5 million plus per person that you can give away during life or at death and not pay any estate tax, federal estate tax. California has no state estate tax. So that's that. But we also know something about that number. In 2026, it's going to come back down to what it was in 2017 plus cost of living. So it'll probably be somewhere in the 6 million range. So that's going to affect a lot more people. So we do have to pay attention to those numbers and talk about that. And there's a lot you can do with estate tax planning with a trust that I'm not even going to burden you with. There's something else that you can do that I didn't mention on this list. If you have disabled beneficiaries or beneficiaries who are perhaps need some incentive to get off the couch and be productive members of society. You can do all of those types of things. Protect them. Make sure they don't lose their public benefits if they're on Medi-Cal or on SSI. Make sure that they have reasons to avoid drugs and do good, avoid evil, right? You can actually empower your trustee to administer random drug tests before they get any money out of the trust. You can do all sorts of parents come to me with questions, and we're able to be very flexible and very creative with trusts, okay? So, and just keep in mind, a successor trustee is who comes in at incapacity or death, and you can have different successor trustees for different situations, and then they continue to act after you're gone to effect your wishes and make sure what you want to see happen takes place. Does anybody know what that is? That's a trust that you forgot to put the house in. So I mention that here because a trust only controls the assets that it owns. And so many times I get this in my office, and they have the world's most beautiful trust, but the shoes and clothes are all still in the closet, and it's not getting them anywhere, okay? So if you have a trust, make sure that title to your assets is held in the name of the trust, all right? And we can do that with just about everything. There's one exception, and that is retirement accounts. Okay, we cannot put retirement accounts in our trust because Uncle Sam in his infinite wisdom says that's a taxable event. You're going to pay the tax on that money at that time. So we handle those separately. But every other type of asset, you should at least have the conversation with the attorney about whether that should be held, title should be held in the name of the trust. Okay, and for assets that are not in the trust, you need to have a power of attorney so that there's some way to manage those assets while you're alive but incapacitated, and then at your death, an executor would manage those if need be. But again, have the conversation with your attorney, your legal advisor about making sure that your assets are held in the trust. Interestingly, a good power of attorney will empower your agent under a power of attorney to put assets in the trust, things you acquire later. So, and I mentioned here that you have to have explicit authority. Generally, there's no power to amend your trust. A lot of people ask, can a trust be amended after I'm incapacitated? Generally not, unless the trust actually has that authority in both the trust and the power of attorney. Okay, so I'm just mentioning a few things that come up often as questions. You have to have a power of attorney that works with your trust. Because, as we talked about, if you have retirement assets or certain other types of assets, you may not have those in your trust, and so you need these people to be able to talk to each other, or it be the same person who can manage both of those types of assets. So we're coming up on 10 minutes till the end here. I just want to have you think about how your own plan is. Have you, or the one you're providing care for, done what's possible to avoid conservatorship? So this is generally, again, having a power of attorney and avoiding an unfunded trust, because if you have an unfunded trust and then you lose capacity, conservatorship is going to be something that needs to be considered. Do you have a current estate plan, or are you on the California default plan that's in the probate code? Does your plan maximize the amount of your estate that will go to your beneficiaries, or are there courts and attorneys that get a big chunk along the way? And I have yet to have one person who finished an estate plan in my office come to me and say, I wish I'd waited longer to do this, okay? What I often hear is, boy, I wish we had done this sooner, because one spouse has succumbed to an illness or had a stroke or something like that, and now the options are significantly narrowed, okay? So without further ado, let's open it up to any other questions that might be on your mind. I'm happy to take as many as you might have in the time we have. Yes? Sure. So there were a couple of things in your question. Thank you. First of all, a fair comment was made that I didn't focus specifically on single men or women. Every comment I made about a surviving spouse really applies in the same way to a single man or woman. The idea is, in contrast to if there's a spouse who's living who can do things and manage assets. But in every other case, at that point, they are a single man or woman. So yes, the same applies to an unmarried, never married single man or woman. Same idea is, do not trust that there's this automatic way to get assets where you want to go. But that's a fair point. I didn't call out specifically unmarried men or women, but the same rules apply. Okay. As far as the second part of your question, which was in your specific case, you have somebody that has asked for your help, but you don't really want to deal with her child. I will just say, generally speaking, we are never obligated to help somebody that's asked us to help. Slavery is gone. We do not have to do this, okay? So there are, and you know, tongue in cheek, but there are professional fiduciaries in our county who are eminently qualified to take on these tasks. I would always recommend, when there's some question about whether a person is going to be willing or able to take on the trustee duties or the executor duties when the time comes, naming a professional fiduciary as a backup, at least, to make sure that there's somebody there, so that someone like you in your position has the freedom to say, it's not the right time, I can't do it. But even if that isn't the case, you can still say that, and the judge will appoint somebody else. You never have to say yes. You can very nicely and gently suggest that they name backups in case something happens and I'm not able to help. That would be how I would phrase it. Yes, back to, sorry. So the question was that it was very confusing, and the only thing this kind lady got out of it was that it's better to have a trust than to put up with the rest of these. I apologize. What I feel very much is the time limit. So I would love to spend twice or three times as much time going over each of these concepts. But yes, the general message should be that there is a way through all of this if you don't have a trust. But ultimately, the simplest, most creative and flexible way of administering an estate at death is by having a trust, if you do have one, or if you are considering whether or not to have one. So that is really the message. Yeah. So the question was, how do I exclude a child, and how do I make provisions in my trust to, say, dole out money? Both of those things can be done with a trust. We don't want to exclude one of the children, but we want money doled out. That is a kind, so within a trust, you can say that exact thing. You can say, I want the trustee, whoever's my successor trustee when I die, to decide when money is needed based on their health, their education, their maintenance, their other expense needs, okay? And so the trustee can make those decisions. Now, you shouldn't name the person that you want to make those decisions. That shouldn't be the same person that's your beneficiary, because then they're in an impossible conflict of deciding when they need money or not. So putting somebody else in as a check and balance is often the best way. So it should be within the trust, but all I'm saying is that it's best policy if you don't have the same person who's the beneficiary making the decision about whether the beneficiary needs money. And without any disrespect to anybody in the room, oftentimes what happens is the beneficiary decides they need money. Okay, and so then that's it. All of your planning and wishes are out the window. So it's better to have a trustee that's separate making the decision, and the beneficiary goes and talks about budget and talks about all the things that need to be discussed, and then they get money. What is the normal cost of a trust? I love this question because it's a difficult one to answer. It's how much is a car? You know, it's do you want that? Do you want you want all the features? You want to the answer is it's unique to every person, but I will say it's going to be substantially less than the cost of probating an estate. Okay, and if it's not for some reason, I for one would say this doesn't do you any good. You might as well just go to probate. But I have yet to see that case. So it definitely by many factors less than what it would cost to probate your estate. Okay. Yes, but just come and talk, and we can talk through it, and then give you that information about what specifically it would be. Yeah. The question was how often to update your trust. Well, the law changes fairly frequently, but not all those legal changes affect each one of us. So as a general rule, I say at least every 5 years, take a look at it, blow the dust off the spine, and bring it to your attorney and say, does this still do what I intended? All right. Most attorneys, including myself, will just sit down and go through that with a client without cost, because we want to make sure that's happening. Only if there's work to be done does it make sense to charge a client, but we want to go through it and put your mind at ease and say, yep, this still does its thing. And I will say, trusts that were done 10, 15 years ago often have major changes to the law and can be very much simplified from what they were back then, because the tax laws have somewhat simplified for people. So in the estate tax realm. So there's a lot of trusts that were done in the 2000s or even earlier that have provisions in there that just don't need to be in there, and that will cause extra hassle for the surviving spouse. So it's worth a look. If you have POD on your bank account, so that's pay on death, will that avoid probate? And the answer is, as long as the person survives you, yes. Right? So if you guarantee that you're going to go first, then it's going to be fine. Yes, so the question was about having a signer on your checking account as opposed to a co-owner. And that is something that exists. The problem I see is that many banks, the bank tellers or the people that you try to set it up with, don't fully understand the difference. So they say, oh, you want your daughter on the account, and she becomes a co-tenant, even though that's not what you intended. So if you're setting up, it's very common to have a co-signer to help with checks and whatnot, but that person simply has signing authority. It's like a special power of attorney just for that account. And make sure that's what happens, and that it doesn't become dad and daughter's account or dad and son's account. That becomes, that means there's ownership involved, and now your estate plan may be on its ear. Yes. So the question is, do you have to put somebody as a pay on death if you know you're going to be under the $184,500 that it is right now, for instance? And the answer is no. If you're certain to only have that much money when you die, the issue becomes when people try to do this on their own and then they end up with an unknown asset or some other asset. Say you had a retirement, here's the example. Say you had a retirement account, you were leaving it to somebody who passed away before you. Now that retirement account gets counted as part of the $184,500. Because it comes into your estate, because it's failed in leaving it to who you intended. So you run a risk whenever you name a beneficiary by contract on an account that they're not going to be there. I was, teasing a bit with this gentleman that, if you're sure that person's going to be there, because what happens is when that doesn't happen, it comes into your estate, and if you're over the limit, when you add everything together, you've got a probate, and you may be leaving everything to somebody you don't intend, like that third cousin in Peoria you've never spoken. A life estate on a piece of property that's in a living trust. That's a question that we're going to need a little more time to talk about. Life estates are kind of a different, they're a sidecar to all this. So let's talk afterwards, and this is what I want to point out here. Remember, what was my wife's name? Sarah. No H on that, by the way. So this is really her name. You'll never forget my phone number. If you had that little chant as a child or your grandkids or children, 2468, who do we appreciate? 805-246-SARAH. You can reach me anytime, day or my voicemail at night. But feel free to call and we can set a time and talk about that. It's a great question, but I also probably would take about 15 minutes to answer it. So please feel free, avail yourself of this. I'm happy to sit down with you and answer your specific questions offline. Thank you very much, you guys.